So the problem here is that many businesses do very random spray and pray marketing. And I don't blame them because, of course, we also live in a world where marketing, sales, and PR sort of lumped into one thing. I don't know why they do that, but it happens quite often. And then that sort of really gets businesses really mixed up in terms of what role does each player actually play in the entire ecosystem, right? So because of that, you tend to get businesses that will just try anything and everything because they don't actually understand the core role of marketing, branding, and PR, and how it also plays a role in your business and when to actually use it. Then market readiness, you tailor your message to the audience needs. You're not just being everything to everyone, but you're being everything to that one base or target. And that becomes a lot less overwhelming because when you're trying to be everything to everyone, that's when now marketing really just becomes a task for you. You're going to really feel like this is such a chore, it's a nightmare. But once you understand your market, you understand how they perceive messages, how they receive messages, how they buy, it becomes a lot more easier over time to then do marketing the best way. Consistent marketing, honestly, it just increases investor confidence because the more they see you marketing, the more that you're showing, social proof, or people used my product, or people enjoyed my service. This is what they're saying. This is what we've been up to. This is the team, etc. All this piece of content really comes together and it creates a really great picture for investors to really be confident to say, okay, this person is legitimately running a real business.
Thanks, MT. Appreciate the long introduction there. I'll take it. And good evening to everyone on the platform today. Thank you for the opportunity to share my thoughts on a couple of the legal issues, as well as how we're going about doing our business from day to day and year to year, and even maybe decade to decade. Today's session will be an interactive session. So, MT, you did say that if there are questions, please don't hesitate to raise your hand and so that MT can take note of it and we can then field your questions. MT, just want to make sure that you can see my presentation.
Yes, we can.
Okay, great. Right. So tonight's session will be Legal Essentials, a guide for SMEs. My name is Simon Naicker, and I've been an attorney of the High Court and been admitted since 2015. This is my 10th year as an admitted attorney, and it's been a roller coaster of a ride, but something that I look back fondly on and have no regrets. Life changes every day, but yeah, we've got to keep on going. Just an agenda for tonight, just an introduction about the firm, which is DNA Inc. and our legal services, and then we'll go into what the difficulties facing the SMEs in South Africa, purpose of our business, regulatory compliance. We'll touch a little bit on the shareholders but versus directors, something that we spoke about last year as well, and maybe allude to that as well today. And then we're going to have a chat about contracts, credit agreements specifically, and suretyship agreements, and then look at what types of contracts you need to secure your business for the future. All right, so about the firm, and the firm is DNA Inc. As you can see, we've got a helix there. If you get into our website, www.dnlaw.co.za, you'll see what's in our DNA, and what's in our DNA is legal solutions. We currently have 2 directors, myself and Donovan Naidu. We're BBEE level 1. Offices are situated in Sandton, and we also specialize in conveyancing and notarizing. So if you have any property transfers and so on, you can speak to us, as well as your commercial law, family law, and any litigation needs that you may have. Really great at debt recovery as well. If you also want to have some conversations about the administration of deceased estates, it was quite one of the popular topics that came out in last year's session. Please don't hesitate to reach out and we can have a chat. All right. Any questions before we move on? All right. Okay, so in South Africa currently, SMMEs have an essential role to play in the economy of South Africa. However, we've been faced with a number of difficulties, and that being economic uncertainty. Just to touch, of course, on the budget speech, and then the Trump-Ramaphosa interaction, which is having a knock-on effect on us in terms of bilateral agreements and multilateral agreements with the nationals and multinationals. But it is affecting us in our pockets. The second one, and I've got it highlighted simply because it's the areas that we will be concentrating on, is the access to finance. As an SMME, it's becoming more difficult to gain access to finance. And corporates are looking at regulatory compliance. You've got to be compliant in order for us to do business with bigger partners. Fourthly, technology adoption is becoming, if not a must, it's become primary importance today, that everybody is not just technologically savvy, but moving their business in a way that people can relate and interact with your business on a high technological level. And then finally, cybersecurity threats. I'm sure many of you may have been approached by or have experienced cybersecurity threats. I'll tell you about a lady at my church recently who got caught up in a WhatsApp scam. She got a message from a so-called friend of hers asking for 1,600 Rand. And she quickly sent over the money, only to get another message saying, I needed 2,800 Rand more. And then only did she realize that there was a problem. Only to find out that a friend's phone had been stolen and her WhatsApp had been hacked, and all of the contacts were sent messages to send the friend money. So it's very important to keep that in mind. Also, in terms of the data that you hold, and you would know that the POPI Act, which we spoke about last year, is really putting us a high constraint on all businesses, irrespective of small or large, to ensure that they safeguard the information of their customers and ensure that their database is properly secure. If you'd like to have a chat about that aspect as well, please reach out to me and we can have a chat about that. All right. I'm not too sure as to the specialist interest around our meeting today, but I thought I'd touch on this as a start. What were the reasons for you starting your business? And maybe you can just type it in the chat. Any one of these options. Maybe it started as a side hustle or a way to supplement an income. Legacy. If you've been involved in the family business, it's your grandfather's business, your dad's business, your business, and you're continuing the legacy for your children. Or maybe you had a specialized skill that you then were able to monetize and put into a business form. You saw a gap in the market and took advantage of that. Maybe customer satisfaction. Your place of employment was not satisfying customers and getting them to come back. And you thought, well, here's a chance for me to capitalize on that. Or you've got a startup and you're thinking about selling at a later stage, which seems to be one of the key areas of business today, as to how to make your business not only profitable, but palatable to a potential buyer or potential investor at a later stage. And then finally, and I think most of us have started businesses on this one, is just to put food on the table, make sure that our kids are fed, going to school, and just paying the bills. So yeah, just type it in the chats if you can, and I'll read them as we go on. Let's move over to regulatory compliance. There's some key aspects of regulatory compliance. The first of all being business registration. You know that in South Africa, you've got to decide what type of entity you want to utilize. Most of us have either closed corporations or previously closed corporations, but now have companies with limited propriety. Having those businesses registered through the CIPC, making sure then that all of the documentation and details are in order. So if someone wants to find you, they can do so and legitimize your business. The next part then being tax compliance. And I know that I get a lot of clients asking me, how do I stop paying as much tax as I used to, or I am currently paying, and look for ways in and around it. I have to be honest with you, it's one of the most challenging parts of our law, but it's a part that can be discussed, it can be worked on. And for those of you that are quite tax oriented, you would know that there are ways and means to limit your tax liability. Then, of course, you've got your employment laws. In South Africa, our labor laws are quite extensive to protect the employee, and to a lesser extent, in my opinion, the employer. The employer does have some sort of protection, but not as much as the employee. And that goes to the extension of, in terms of how they can exercise their rights through mediation and arbitration, and thereafter, of course, through the labor court. Consumer protection. We've got the Consumer Protection Act that governs our relationship with our customers. What can we contract on? What can't we contract on? For how long those periods are? And then, of course, you've also got the Consumer Protector that overlooks and oversees the relationship between consumers and clients and consumers. Finally, data protection and privacy, we spoke about that. That's become really big. For those of you that have not really looked into it, I would suggest that you put some time in terms of ensuring that you consider data protection and privacy, especially with regards to the information that is easily accessible either through your own laptop or your own devices, or that of your employees, to ensure that you also have the right policies in place, because there are hefty fines to be paid for the information officer, who in a SME environment is normally the director/shareholder. One of the other ones that I will touch on a bit later, and we spoke about future-proofing your business, is intellectual property, the benefits of trademarks and copyrights. And I previously had a conversation with some of the guys at Mido, and in terms of trademarks and copyrights, when you start your business, if you're a startup and you've got a great idea, you definitely need to secure that those marks, especially the copyrights or patents that you have, simply because you don't want someone stealing it at a later stage and utilizing your hard thought plan for their own financial gain. Then, of course, you've got occupational health and safety, which is mandatory, financial and secretarial record keeping, and then, depending on which industry you're in, your industry-specific compliance with specific boards and or committees governing those areas. All right. So why comply? Why why take the step towards regulatory compliance? Compliance enhances credibility and trustworthiness. When people access your website or your mobile platforms, they're able to see that you have certain policies in place and that you've complied. It gives your business that sense of credibility. Non-compliance leads to financial implications, penalties, fines, and a potential loss of opportunities. And I've seen that in previous places of employment where that does take place, because especially the bigger players are looking to join with people that have a lower risk in the market. And so that's very, very important. Stakeholders, including investors and customers, value businesses that operate within legal frameworks. And that sometimes is difficult as you start to grow in your business. Over time, you start to pick up maybe habits, business habits that are not necessarily falling within the legal framework, but it works. And it's good for you to be introspective and observe whether those practices are just going to earn you short-term gain, but long-term losses. And so sometimes it's best to have that overview to see what processes are in place and whether you've codified those processes as well. All right. Any questions, T, on your side?
Nothing as yet. I think people were just, answering your question from earlier regarding the motivation as to why they started their businesses. And there were some interesting answers, a mixed bag of answers really, between specialized skills, putting food on the table, survival. Someone said they just wanted to explore and challenge themselves as well. But I thought maybe let me just read some of those out for you.
Yeah, go for it.
Yeah. But if there are any questions, please feel free, as I said earlier, to type it in the chat or, raise your hand, and Simon will attend to those. But yeah, I think you can proceed, Simon.
Thanks, MC. All right, so this is the one part that I thought I'd touch on again. And what is the difference between a shareholder and a director? Is a director a owner of the business? Is a shareholder the manager of the business? Now, I know that in the SME space, we have a lot of times that the shareholder is the sole shareholder, and then, of course, the sole director. I think in the chat, if you can put this down, whether you are a shareholder or a director. If you play both or you use both hats, you can there. I've got both hats on. Or if you're a shareholder, you can say I'm a shareholder or just a director. All right, so here are some of the key aspects or characteristics of the shareholder and what they do. Shareholders own a portion of the company through the shares. So there's a share certificate, and that is generated by the company that gives or notifies CIPC as to who the shareholder of the company is. This is the person that normally institutes the company together with a memorandum of incorporation. And if there are more shareholders, one or more or two or more shareholders, you have a shareholders agreement. How many of you, by show of hands, have a shareholders agreement in place? Okay. So what are the great things about a shareholders agreement? A shareholders agreement helps shareholders within the business to resolve difficulties when they arise. I'm going to say this, and you'll hear me say it quite often, is that it's better to contract at the start of a relationship than to contract in the middle of a relationship, or worse off, to contract when the relationship is over. For those of you that are married or considering marriage, I would suggest that you would know that it would be best to contract in the dating phase. That's the best part or the best time to contract, simply because the parties are at, can I say, they share the same goals, they share the same vision, and are able to talk about issues without having too much of difficulties. They want to impress the other. But when the relationship begins, it changes. For example, I heard a good example of a guy says, when I use toothpaste in the morning, I like to press the toothpaste from the bottom. My wife, on the other hand, she likes to use the toothpaste just anyhow. That is just an example of the toothpaste. You're still getting the toothpaste out, but somebody likes it done in a certain way, whilst the other person just cannot be bothered. That's the same thing that happens within businesses. And for those of you that have been in businesses that, where relationships have gone a bit sour, you would also realize that if you had a good agreement in place, separating or divorcing would have been much more easier. Thirdly, shareholders elect directors and have the right to vote on certain matters. So it's the shareholders that elect the directors. The shareholders are the ones that hold the power to appoint directors. The directors are responsible for the management, the day-to-day management, where the shareholders are looking at the overall performance of the company, and the directors are responsible to the shareholders. Let's talk about the directors. Directors manage the day-to-day operations and are accountable for the company's performance. I'm going to spend a little bit of time on this aspect, and so I'd like you to consider this. Directors have a fiduciary duty, that means a legal duty to act in the best interest of the company. And we find that in Section 76 of the Companies Act 71 of 2008. And so for those of you that have not considered this section, I would suggest that you do. I'm going to go through some of the fiduciary duties so that you are aware, and maybe you'll be able to apply your mind to see as to whether you are acting within the best interests of the company or not. So number one, they have a duty to act in good faith and for a proper purpose. So that means when they act, they have to act with good intention, and ensure that the purpose that they are acting in is also proper. Making sure that when somebody does question that, they are able to respond and to provide documentary proof as to why those actions were taking place. Number two, the duty to act in the best interest of the company. And so this is a good one because you often have, on some occasions, people that would think that the company is although it's a separate entity, it also represents themselves. And so they conduct business for the company, but they also conduct business for themselves. And you'd see that with employees, for example, the directors, where they would have maybe businesses that would compete with the company. Directors as well have a duty not to compete with the company. And so if they are found to be acting outside of the best interest of the company or to the detriment of the company, they can be held personally liable for that, and we'll speak about that just now. Number three, they have a duty of care, skill, and diligence. So they have to act, again, with care, skill, and diligence, meaning that the decisions that they make from the day-to-day running of the company must be done properly, must be done carefully, must be done in accordance with the law, and must advance the purposes of the company. Number four, there's a prohibition on using position and information for personal advantage. So a director should not be using his position or the information that he gains from the company to better his personal status or to utilize that to sell himself better. Now, I think you've already got some people in mind about about this aspect, but it's important to ensure that when you are acting, you have to act without trying to advance your personal gain. Right. Let's have a look at what are the consequences of breaching Section 76, the fiduciary responsibilities or duties of a director. It can lead to legal action and personal liability for the director. This is a very critical point in our law currently with the aspect of personal liability for the director. You would also have heard of the terminology of lifting the corporate veil. And so can the corporate veil be lifted so that the director is held personally liable away from the entity of the company? And if anybody had to apply for that, whether it be a creditor and or a member of the company, then they would have to prove why the director should be held personally liable for debts and or damages. The company may be able to sue the director for any losses or damages that their misconduct has caused. You would see this now coming to the fore in our public sector, and so it's very, very important to understand that the actions of the director cannot just be reckless. It has to be well thought out and well played out to ensure that he also covers himself when acting. We spoke about the aspect of as to when a director can be held liable, but currently Section 76(4) speaks about the business judgment rule. That means that if a director can make an informed and rational business decision, he would be absolved from personal liability on the decisions that he's made, provided that those decisions are made in good faith, for proper purpose, and after due diligence. In essence, Section 76 of the South African Companies Act sets out the ethical and legal obligations of directors to act in the best interest of the company and avoid any actions that could harm it or give them an unfair advantage. I'm going to pause here to see if we have any questions, MT.
Yes, we do. So we have two questions. So I'm going to start with a question from Sean. He asks, how can I protect my business plan or idea? What are the steps that I must follow? Yeah, that's from Sean.
Okay. So Sean, let's get to yours. We're going to get to your questions slightly in the next, well, say 4 slides. So we'll come back to the one, MT.
Okay, cool. And then Matapelo asks, she says, my partner and I share 50-50, and that's stated on the BBBE certificate. Does that aid as an agreement? I think this is speaking to the shareholders agreement question you had earlier.
Yes. Matapelo, thank you for that question. Yes, you may share 50-50 in terms of the shareholding of the company. But where the shareholders agreement is important is in terms of when you have a difficulty. And so it's important that you have a well-crafted shareholders agreement that ensures that the rights of both shareholders are considered, and that in the event of, like I said, a disagreement, how do we resolve that? What happens if one of the shareholders passes away or is incapable of handling his affairs any longer? What takes place there? What happens in the event that one is sequestrated or it faces an insolvency action? what happens to that? So all of those key aspects are taken care of as well in the shareholders agreement. I hope that answers the question, Tim.
Thank you. Thank you, Simon. I think it does. If there's any, oh, I see a thumbs up, so I think she's happy with the answer.
Okay, great.
I think you may proceed.
Thank you. All right. So let's talk about contracts and credit agreements. And, we spoke about earlier that having access to finance is key to growing your business. But unfortunately, it's become a very delicious starter, main course, dessert, and poison for a lot of us. And I've got a picture of the credit score here. How many of you know what your credit score is? You can just raise your hands. For those of you that have a credit score over 700, well done. For those of you that are trying, I'm still trying to figure out which is the best way to go. For those of you that have a great credit score for your company, raise your hand. So two separate entities, your personal and then the company, right, which is a separate entity. So a couple of starters, the definition of contract. Contracts where one party borrows money or goods from another. This is a credit agreement. And the legal framework is governed mainly by contractual law. Credit agreements are regulated by the National Credit Act, the NCA. For those of you that have taken out credit with respect to either finance in terms of the business or a bond on a property or a vehicle asset finance, or even a credit card, you would see that the NCA would be applicable. It's important to understand that the NCA tries to protect the debtor through various means and forms of mediation. However, it doesn't mean that you can escape credit and try and escape action by the creditors. I would like to maybe tell you a story about a client's daughter that I recently consulted with, and she's not working, but she said that she was able to get a credit card with one of the banks for 5,000 Rand. Her dad gives her a can call it subsistence of 3,000 Rand, and the bank gave her a credit card of 5,000 Rand, and she said, I'm so excited because now at least I've got a credit card, I can build my credit score. And my question was, why are you building your credit score? So I can take more credit. And for those of you that are quite business savvy, you know that that's not the great reason for taking credit or having a better credit score. All right, so the types of agreements we spoke about are personal loans, credit cards, hire purchase agreements, leasing agreements, and the terms and conditions of these agreements normally include repayment of the loan or the credit and interest, rate and term, as well as fees. That could be including the fees to draw up, the administration fees and or legal fees. The one thing that makes it difficult, especially as a business owner, is that when you go to take credit for your business, the creditors or the creditors are really looking at how can they secure the repayment of those loans, and so they then look at an agreement called a suretyship agreement, and this is the difficult part. Because for SMEs, most of us are looking to take finance for the business, but we are the only surety that can stand for the business, unless you've got some investors. But this is where it becomes very difficult, and I'd like to share some thoughts on that aspect as well. Suretyship agreements is a contractual agreement where a surety personally guarantees the debt of a principal debtor. So in this case, we would look at a vehicle asset loan in the name of the company. And the company is taking a loan from the bank, but the surety is the business owner or director who is standing in surety for the debt of the principal debt. So in the event that the company is unable to pay and meet its obligations, the principal, the surety will then step into the, or will then be liable for the debts owed to the creditor. And so what takes place there? There are three parties involved: the principal debtor, the creditor, and the surety. And it's formalized with the deed of suretyship, a formal written guarantee from the surety to the creditor. Surety's liability is coextensive with the principal debtor unless stated otherwise, meaning that the surety is held as a co-debtor or a co-party to the principal debtor. And that means that the creditor can then issue legal action against both the debtor and the surety at the same time. That can put you in a very difficult and a compromised situation, especially if you need access to more finance. And so I'd like you to consider that and think about that. Right. So if the business is unable to pay its debts, then it's more than likely that the creditor would go through a debt recovery or debt collection process. That process involves sending letters of demand in relation to probably the more than likely through the NCA. Then thereafter issuing summons based on the terms and conditions of the agreements. That's the credit agreement and the suretyship agreement. And thereafter giving you an opportunity to respond formally. If you do not respond, then the creditor may apply to the court for a default judgment. A default judgment means that you haven't responded formally to the court process, and the court is now going to give the creditor a judgment in their favor for the capital, the amount that you owe, for the interest, and for the legal cost. In the event that both the debtor, that's the company in this case, and the surety are cited as parties, the judgment is given against both. And the default judgment then, and you'll probably remember this one here, goes to the credit bureaus who blacklist you. That judgment is then on your name for a period of 30 years until satisfied. So very, very serious consequences to that aspect. Secondly, the surety's obligations can be called upon even if the debtor is solvent. So it doesn't mean that the debtor is insolvent that the surety then comes into play. That's not the case. As soon as the debtor goes into default, the creditor may then issue action against the surety for the non-performance by the debtor. Finally, under the NCA, certain credit agreements have prescribed rights and remedies. And so when we look at that in terms of the credit agreement, there is a number of processes that have to be followed by creditors in order to enforce their rights against the debtor. If you'd like to have more information about that, please reach out and I'll be more than willing to have a chat with you about that. All right, any questions there, MT, before we move on to our last slide?
Thank you so much, Simon. There's two questions in the chat.
Yeah.
Okay, I see Comfort has his hand up, so maybe one of the questions was from him. So Comfort, I think you can unmute and ask your question.
Sure, thanks, MT. Hi, Simon.
Hi, Comfort, how are you doing?
Good, man. How are you doing?
Good.
Good. Okay, so one is, where do you get the credit score for your business? And then the second question is on the issue of the default judgment situation. Okay, so I'm asking this because we're currently in a situation where we've instituted court proceedings on another business that we had agreements with prior.
Right.
And we are now at a stage where summons had been issued, no responses have been received. And so our attorneys are pursuing default judgment. But I'm asking this now because I actually just realized I haven't thought to ask this question, which is, what happens after default judgment other than the debtor being placed on a, what you call it? On a blacklist, yeah. What is that all that happens? And then you just have, is it until you because you mentioned that you have to, until you fulfill the obligation, that blacklist remains. What exactly does it impact? I'm just trying to understand the extent of the impact of that blacklisting.
Okay, let's deal with your first question. So with regards to the credit score for a business, Experian, TransUnion, you can make contact with them and they'll be able to advise you what your credit score for the business is. I know that some of the banks and the financial institutions themselves keep that credit score, so you can have a look at that and engage with your banking partner to establish that. Then with regards to the enforcement of a default judgment. So if a default judgment remains unsatisfied, apart from the blacklisting, then it affects any person that wants to engage with you in business on a credit basis. So for example, someone wants to extend credit to you, they would look at your blacklisting status on the credit portfolios, and then establish that you're not a suitable candidate for that because you hold a high risk not to pay them back. Then secondly, you wouldn't be able to buy or obtain further finance, which restricts your access to assets and maybe even trying to grow your business. And then finally, in terms of the blacklisting, you might want to move places, so you've got to rent somewhere else. Your potential landlord would say, well, what are the chances of me getting my rental back if you're blacklisted? And so those are the risks that are posed there. With regards to the enforcement of the default judgment, you can then look at a warrant of execution. So then you look to attach the assets of the credit of the debtor, have them sold by the sheriff to satisfy the debt that's owing, or proceed to an insolvency application. So that's liquidation of the company, which would then render the company unable to trade any further unless they have the assistance of a liquidator. It has major impact, like I said, in terms of the functioning of the business. Does it answer your question?
Absolutely. Thank you so much.
Okay, great. MT, you said there was one more?
Thank you, Comfort, and thank you, Simon. I think on the back of Comfort's question, maybe Matabelo's question is relevant. So she asks, does my personal credit score affect that of my business?
So it will affect your business in terms of the surety. If you're going to be standing as a surety, a finance house will definitely look as to what you have on your name, and that means if they can't get a surety for the principal debtor, it's highly likely that you will not qualify for the finance. So that has a negative impact there. Yeah.
Right, cool. Thank you, Simon. I hope that answers the question, Matabelo. And then there was a question from Susan. So
Yeah.
Susan says, I don't know if my question is relevant, but I need to know when it comes to finances, how does one deal with a loan from an individual to the business? Especially when somebody comes in to assist
Yeah.
the business in purchasing the stock instead of actually transferring the money in the company's bank account. What does SARS say about that?
Oh, so that I have to be honest with you, we'll have to deal with that quite extensively. But let's
Yeah.
talk about the initial part. The initial part is the contracting arrangement. There must be a contract between yourself and the person, the company and the person that is supposedly giving the loan to detail what are the terms of that loan. That needs to be firstly put into place. And then, of course, in the event of breach, what happens in terms of breach? With regards to tax implications, that will also be dictated to in terms of that agreement and what is in the best interest of the company. And of course, not looking at tax evasion rather than limiting liability. I hope that answers the question in a very summarized way. Yeah.
Without getting too into it. But thank you so much, Simon. I think maybe if there's a follow-up, Susan, you can just type it in the chat. And then I see Sarah has her hand up. So Sarah, you
Okay.
can go ahead, unmute and ask your question.
Hi there, can you hear me?
Yes, we can, Sarah. How are you doing?
Okay, I'm great, thank you. I just wanted to ask, I don't know if this is related, but when it comes to doing business with like big business and they ask you to sign an NDA and they require you to, like, for example, do a sample for them, can you make them also sign an NDA so that, you know, if they decide not to go with your business, then they must not take the sample and circulate it to other suppliers, for example?
I think you're reading my mind, Sarah. Here comes the next slide. And see if, with your permission, I can move on.
Happy.
All right, let's go. So I can't remember the name of the person that asked the question earlier on with regards to the trademarks and the copyrights. And here we are, Sarah, with the non-disclosure agreements. And so these are contracts that secure your business. You don't want people to run away with your ideas or your products. And so how do you do that? You safeguard before actually meeting with them. You get them to sign a non-disclosure agreement. Please speak to me and I can assist you with that. I've dealt with a number of businesses where, you know, we want to enter into it. We get excited because we've got an investor or we've got a partner that wants to come on board. And so we express our ideas and our business plans, and then suddenly it's no longer ours. And we don't have much to go back on apart from the fact that we had a conversation. The non-disclosure agreement covers a vast number of areas, not just the confidentiality, but in terms of who can utilize it and where. And then, of course, for what period is the non-disclosure agreement? So in this case, we don't want people competing with us. There'll be a non-compete clause to make sure that we safeguard all of your interests. So please, especially if you've got a business where you've got great ideas, whether in process or in product, I would then suggest that you first start off with non-disclosure agreements. Yes, it will cost you a little bit of money, but it will save you a whole lot of heartbreak in the future. Maybe I can also point to on that page of the trademarks and the copyrights. So the patents and the trade secrets, you want to copyright those patents before you get too involved. You need to also establish whether the patents that you have already come out or whether you need to register them. Patents are registered in a specific country, and so it's geographically reliant. So if you need a patent to be registered in another country, you've got to apply for it there. And then, of course, your trade secrets. All of us clearly know the KFC one of their herbs and spices. Nobody knows exactly what's in it, but it's a trade secret. How did you get there? Or maybe you make lovely cook sisters and you've got a special spice that you use that makes it delectable and delicious. But you need to protect that, and so that's why we go down this route. What's also great to have are service level agreements. So service level agreements, just like the shareholder agreements, put into place how we're going to communicate and regulate the relationship between ourselves and our clients, or ourselves and our suppliers, contractors, or contractors and ourselves. But it also has in place what happens when we don't see eye to eye, or when we don't necessarily keep up to that agreement. Who has a right and how do they enforce that? It's very, very important to have it at the start of it rather than trying to get it done in the middle of it. And so it's very important to ensure that you have breach clauses and dispute resolution to limit legal cost and the time to recover and or enforce debt recovery. Now, for those of you that are aware, there is something called the Prescription Act, which allows us to recover debt from 3 years, for a period of 3 years from which the debt became due or becomes due. So if the debt becomes due on the 21st of January 2022, that debt would have prescribed on the 20th of January 2025. And so by law, you can recover. However, the debtor then may be able to raise a defense of prescription, saying that in law, your claim has prescribed and therefore it cannot be enforced. Very, very important, especially for those of you that are holding debt books, bad debt books for a long time. I would suggest that you speak to an attorney or speak to a recovery agency to get those resolved upon. And then, of course, the biggest part is, of course, the value of the rand. So maybe 5 years ago, even 3 years ago, the value of the rand was much stronger, meaning that we could buy a lot more with 1 rand than what we can buy now. So a lot of people try and delay the debt collection process, but it's better to do it as soon as the breach happens rather than wait for a later stage, simply because it takes a longer time. And as time is going on, you're paying for the service and you're also losing on the value of the rand. So I would encourage you there to ensure that you do enforce your debt collection strategies there. Nti, I'll take some questions here on this aspect, and then I'll wrap it up thereafter.
Awesome. Thank you so much, Simon. So I see 2 questions maybe on this aspect that you've just covered. So Joy was asking, perhaps this is a question she could ask after the session as well. So how much is a non-disclosure agreement? So what are the rates?
And you know why I'm laughing, eh?
Yeah.
So I can answer that question quite succinctly. Joy, I think it's best to understand what you are looking to protect, and therefore, so it would be better to consult for me to understand, and then to advise you as to what it would cost for an agreement. So yeah, please reach out to me and we can definitely have a chat.
Awesome. And then Kagiso asks, who has the right to sign an NDA in a big company that you deal with? Is it a rule of thumb that any manager is allowed to sign an NDA, or is it company specific?
It is company specific, because remember that the directors would have to empower other staff through a company resolution in order to sign on behalf of the company. So by right, you should ask for a company resolution that gives that person the authority to sign on behalf of the company.
Awesome. Thank you, Simon. I hope that answers the question, Kagiso. Oh yeah, I think Kagiso's happy. I think we at a point where I don't know. I see Sarah's hand is still up. I don't know, Sarah, if maybe you had a follow-up question.
I
Okay, so she's
did.
okay. I think you can go ahead.
Thank you, Simon, for the response you gave. Just to ease my mind a little bit, like, okay, so say they signed this NDA and they're a big business and they're dealing with you as a growing business, and then they decide to go against it. Now it's sort of like a legal matter, and obviously we don't have the budgets that they have for legal fees. You know, I mean, does it really stand? Does it really stand? NDA when big business is dealing with a growing business?
Yeah, in fact, financial power or clout shouldn't be the defining factor in justice. And so, I think a great case in that circumstance now would be the Vodacom Please Call Me case. And as you can see, is that it's more valuable as time goes on, but there are legal costs to be paid there. And I would suggest that it's your idea, it's your baby. You may not come up with a better idea than the one that you have, with the product that you have. I'm not saying that you wouldn't, but there is a possibility. So you need to fight for it. And yeah, that's in the best interest of the company. And yeah, don't let that aspect sway you that someone's got more money to keep you in litigation. You have to fight for what's right. And that's why the attorneys are there.
Amazing. Thank you so much. I appreciate that.
You're welcome.
All right, I'm happy for us to wrap it up here, Simon. So I'm going to hand over to you for some closing remarks and then we'll close.
Okay. Thanks so much, MT. I really enjoyed the session, although I've been faceless. I hope that I'll be able to meet some of you, or if not all of you, in a face-to-face setting, get to know you and your business. But my details are on the screen. Please don't hesitate if you want to give me a call, set up some time to have a chat. I am more than happy to also give you the MyDAO family and friends discount, if that's appealing to you. But you'll have to say I've been referred to by MyDAO when that comes through. So yeah, my email is simon@dnlaw.co.za. My cell number is 082-574-9329, and our web address www.dnlaw.co.za. All right, MC. If there's anything else, I'll leave it to you now.
Thank you so much, Simon, and thank you so much for the generosity extended to our community and ecosystem. I really implore and encourage everyone to take that up while it's still, available. But Simon, we really do appreciate your time and the partnership that we've been able to build with yourself. Hoping that it will grow even further, and that will bring you back for more sessions. There's definitely a lot of interest, around anything legal and compliance related. So there's always going to be, room for you at MyDAO. And thank you so much for availing yourself and for always heeding the call. We do appreciate that, and we appreciate you as well. Thank you to everyone that joined the session tonight. Thank you for spending your evening with us. We will be back for another one of these sessions next month. I believe that will be at the beginning of July, the 3rd of July, where we will be tackling leadership and team management with recruitment and HR specialist Buhlali Baile, but we will share those that communication rather in due course, just for you to make time for the session. And lastly, I just want to say we are having our Popcorn and Pitch event later this month on the 20th of June, So if you have not yet purchased your ticket, please go to Quicket to secure your ticket, where you will get a chance to experience pitches from 10 amazing businesses. The top 10 will be announced soon. I know some people on the call actually applied to be one of the pitching businesses. Please be on the lookout on our socials for the top 10 announcement. But if you will not be pitching on the day, I do implore you to still come through and hear some of the pitches and the feedback from our judges, and you'll also get to vote for your favorite as well. There's a People's Choice Award that we'll be giving out in the evening, but please do go to Quicket to purchase your ticket. Otherwise, thank you so much for your time. Wishing you all a lovely evening and an amazing weekend ahead. Thank you so much.